Good morning, everybody. Thank you for joining us today. I'm Julie Ban, Head of Employment here at Sharpe Pritchard, and I'm delighted to say that we have Angela Ferguson here, Director and Head of Employment Taxes, to cover this session on IR35 legislation. For those of you that haven't worked yet with PS Tax, we've worked with them for a number of years now, and we know them as one of the leading providers of specialist advice, tax and VAT services to the public sector, but I understand they also work with the private sector and the third sector. They work with over 300 public bodies across the UK and have recently, as of May 2024, hot off the press, won Best Employment Taxes Team at the Tolly Tax Awards in London. And not only do we have PX Tax here, we've obviously got Angela, who has a substantial amount of experience within taxation, having trained with one of the big four and worked there for most of her career. And Angela does specialise in IR35 and off-payroll working alongside national minimum wage and salary sacrifice schemes. So she's perfectly placed to support us in this session today. We are recording it. If you do have any questions, you can put them in the chat function or the Q&A function if it's there, and we will answer those as we go along if we can do, or otherwise at the end, and we'll anonymise them. If you want to ask a specific question, if you wait till the end, we will stop the recording and you can raise your hand and you can ask it then. But unless anyone's got anything pressing for now, I'm going to hand over to Angela. Thank you very much, Angela.
Thanks, Julie. Thanks for having me today. So yes, as Julie said, I'm going to be covering off IR35 or off-payroll working. It's something obviously that, as Julie said, that I've specialised in for a number of years. So without further ado, I'll just run through with you the agenda and what we're planning on covering this morning. So just initially, just a recap of the changes that came in April and what your obligations are from that date. Then I'm just going to talk about employment status in general, whether you're engaging a self-employed sole trader or somebody who operates through their own personal service company, PSC, as we like to shorten things and give everything a million acronyms. But the tests are exactly the same for both. It's just your obligations that will be slightly different depending on who you're engaging with. So I will then obviously touch upon what those obligations are when you're engaging with a personal service company. And then touch on the HMRC's check employment status for tax tool, assessed, and things there that you just need to look out for. Really, with this S tool, it's understanding the questions properly and answering them correctly, and then whatever the output is can be relied upon. And then finally, just to comment on some new rules that came in from April of this year, where you're engaging with a personal service company, and the fact that should HMRC decide that you've made the wrong decision, that somebody is outside of the off-payroll working rules, you can actually now claim offset for any taxes and national insurance that have been paid by that personal service company. But I'll cover that in more detail when we get to that part of the presentation. So what's the sort of brief recap in terms of where we are? So off-payroll working, or IR35, it's really important just to understand exactly who it is you're engaging with. Where you're engaging with a self-employed sole trader, for example, they don't have a limited company, so it's just Joe Bloggs, not Joe Bloggs Limited. Then that person as a self-employed individual, you as the engager or the user of that individual's services have always had the obligation to assess their employment status. So nothing has changed. So these new off-payroll working rules purely have been brought in to bring in new obligations when you are engaging with a personal service company. So I think quite a lot of clients kind of perhaps overlook the fact they did have this obligation with sole traders or self-employed individuals, but nothing has changed there. What has changed is the new rules came in for the public sector back in April 2017 for where you are engaging with a personal service company. It also then expanded out to the private sector from April 2021. And so it was hoped that at that point in time, it would be a level playing field. Public and private sector still have the same obligations. However, at that time, both sectors have additional reporting obligations. So what are those? Basically, what you have to do as an engager, so if you're a public body and you're engaging the services of somebody who operates through their own personal service company, or PSC for short, then you have to make an assessment of whether you believe that individual is genuinely outside of the off-payroll working rules, which means that you can just pay them as normal, pay them when they send you an invoice, and you don't have to apply tax and national insurance to those payments. Or when you make the assessment, you actually think, no, this person who's trading through a personal service company, if it wasn't for that personal service company, they would be our employee. You then have to apply tax and national insurance and treat them as a deemed employee for tax purposes. And the way that you do that is you carry out the assessment and you make a status determination statement, and that has to be issued to the worker. And any other organisation that's in the chain. For example, if you had an agency, you actually, from April 2021, had to keep sort of detailed reasons of how you arrived at that determination. And then you actually have to have processes in place since April 2021 if that worker appealed. So it's called a disagreement process, which basically means that you have to respond within 45 days of receiving an appeal. So quite often, obviously, if you find that somebody is within IR35 of the off-payroll working rules, that means you have to apply tax and national insurance. Oftentimes, that worker is not going to be happy about that, so you will get an appeal from them. So you have to have an appeals process in place. We also had some recent guidance in December, which I wanted to bring to your attention. HMRC refreshed their guidance on off-payroll working. And what they said is set out on this slide is that every engager, so every public body or organisation that engages with workers needs to have adequate internal training in place. So obviously coming to a session like this is great, and it kind of helps tick that box that you are attending topical sessions and keeping up to date with the rules. But just bear in mind that anybody within your organisation who is completing a status determination statement or engaging individuals and has that obligation needs to have that adequate training. So that could be something that you put on internally. It could be something that you look for external support on. Of course, myself and everybody at Sharpe Pritchard will also be there to support you with internal training. We have various offerings between us where we can support you. But it is critical, because if you don't have that in place, then should HMRC come out and carry out a review and they see that you've got no internal training in place, they will look very poorly upon that when it comes to looking at things like penalties, because it's based on reasonable care. So if you've got training in place, then you will be taking reasonable care. And should HMRC then come out and disagree with you, then at least you've got that in place. They would then look kindly upon you when looking at penalties, and hopefully you could secure on any settlement a 0% penalty, which is obviously ideal. We can't always get everything right, but if we've got the right methodology and structure in place, then that obviously helps to support the fact you're taking reasonable care. So as I said, we've got some basic principles with employment status, which I just wanted to run through. So what does employment status mean? Well, you've got various different scenarios of people that you're engaging with, workers you're engaging with, and it's really important that you understand exactly who you are engaging with. Sometimes it can be quite complicated where agencies are involved, and it's really important just to truly understand, are you engaging directly with that individual, or is it their personal service company? Is there an agency in the chain? You really need to understand who it is that you're engaging with. So as it says on the slide, we've got people who are employed or they're self-employed. So that's your sort of sole trader type person. We've got office holders, which is really important to understand, because if you have an office holder, they're straight into pay as you earn. You don't need to even look at some of the employment status tests, because it's just you're straight into pay as you earn. So you don't need to go through the whole status determination statement process. We've got what we call contract of service, which is your employment contract, or your contract for services, which is typically somebody who's a consultant or engaging through their personal service company. We've obviously got the differences between whether if they're an employee, then it's pay as you earn. If they're not, then obviously they'll be paying tax through self-assessment. And then we've got the differences with national insurance. As an employee, we've got class 1 national insurance. When somebody's self-employed, then they are looking at paying class 2 and class 4. And this is exactly the same when we're looking at personal service companies as well. We have a raft of different national insurances going on. So why is it so important? Well, it's actually your statutory obligation as an engager, as a public body, to actually carry out this assessment. And this is what the off-payroll working rules brought in. Prior to this time, it was up to the individual who had their own personal service company to self-assess themselves. And obviously, not a lot of people were self-assessing themselves and putting the hand up and saying, yeah, I think I should be taxed as an employee. So what HMRC did was look at that. They didn't have the capacity to go and obviously go around the hundreds of thousands of personal service companies and investigate those. So instead, unfortunately, they put that obligation on you to carry out the assessment. So it is your statutory obligation to do that. And obviously, we've got the reasons being is if it goes wrong, then obviously HMRC can come after you for the tax, national insurance, and interest and penalties. And also, then the engager could actually be taken to an employment tribunal as well by the individual, and argue that they believe that they should be an employee for different employment rights. So we've got all sorts going on in terms of why it's really important to get employment status right at the beginning. So we've got lots of case law, which is used when we're looking at employment status. And that feeds into the different tests, which I will come on to later. It's really important that you have got internal guidance and training in place, like I've said. We do have the free tool that HMRC offers, the Check Employment Status for Tax tool. Again, I will sort of come on to that and some of its positives and negatives later on, but it's free, it's there to be used, and HMRC will accept the result, providing the answers have been, our questions, have been answered correctly. So it's really important that you're understanding what those questions mean and what those answers that you're giving also mean. Finally, as well as the employment, the theft tool and the outcome, which I will run through, you can also have an internal questionnaire. The Check Employment Status for Tax tool is fine, it does the job, but you might want to just put an extra layer of compliance there with a few more questions. Lots of clients do that just to really drill into some of these answers to make sure we're actually understanding all the facts from day one. So office holders, as I said, it's a really important area and sometimes it's overlooked. Just bear with me, so get rid of my croaky throat. So, as I mentioned, office holders, it's straight away that if somebody's treated as an office holder, then they are straight within pay as you earn. You should not be paying office holders off payroll. So obviously, if that's a real sort of red flag, something that needs to be looked at straight away with anybody who's engaging office holders, it's something that HMRC will ask as soon as they come out and carry out an audit or an employer compliance review. So they're not employees as such, but they're treated as that for tax purposes. And the definition is there on the slide. So an office holder is somebody that has a permanent substantive position which has an existence independent from the person who filled it, which went on and was filled in succession by successive holders. So it basically means that it's a position there that it's not down to just one individual, that somebody will constantly fill that position going forward. So it tends to be board members, and I've got a few examples in the public sector of where we see certain roles being caught. And the actual definition was really approved in a case which is Edwards v Clinch. And as I've previously mentioned, it's got to be something that's not just set up for one purpose. So it's not a panel that's set up just to review one individual case. It's something that will go on and it's prolonged and it will be filled by another person. Quite often HMRC will look to documents. So it might be something that's created by a charter, a statute, or some other kind of documentation within an organisation that talks about an office holder role. And as I mentioned, here are sort of some of the examples of office holders that we see within the public sector or public bodies. So we've got fire, local authority, and elected members. Coroners is quite a big risk area, and we've actually seen that excuse me, with a recent campaign with HMRC, where they have been looking very closely with police bodies and local authorities, where we've got coroners and medical professionals. So that's a real hot topic with HMRC. Foster adoption panel chairs. So this is the chair, not necessarily the rest of the panel. Certain police and crime commissioners, child safeguarding panel chairs. Again, it's always the chairperson that tends to fall as an office holder. Your section 151 officers at local authorities. And then I've put independent review officers. It really just depends on the facts of the case. Sometimes certain review officers and panels can be set up just to look at one case, and then they're disbanded. They don't carry on. So it's that enduring nature of a panel or that's set up that it will continue, and somebody else will fulfill that chair role. That's really important. So what are the main tests? As I said, I wanted to cover off office holders because we don't even need to start looking at these tests if somebody's an office holder with straight in pay as you earn. But if we're happy that they're not an office holder, then we can actually look at the main tests. Oh, sorry, just a little question which might be quite timely, so I think I just caught a glimpse of that. So look, the office holder in the Constantine meant any role that is permanent in structure as opposed to office holders in the sense of net credit. So a comms manager basically can't be outside if they are covering a vacancy. Yeah, if it's an internal post, so this is probably for anything that's you quite often see them called interim roles because they're covering for something that's would normally be an employed role. If generally you would always be employing somebody in an employed role, but you're bringing somebody in temporarily to cover it, then yeah, you're absolutely right. It can't be. If you're covering a vacancy that's typically an employed role, then yes, that's got to be within IR35. If it's a personal service company, if it's an individual, then it's within they're employed. You don't obviously go through the sort of off-payroll working SDS checks, but you do have to carry out the main test, which I'm going to come on to. So yeah, if you ever have internal roles that are covered by anybody, it could be, interim director of finance, interim head of HR, big red flags. That should be straight pay as you earn without even considering anything any further. So what are the main tests? The main tests are on the slide here. So we've got personal service, control, financial risk, integration, and mutuality of obligation. And I'm going to run through what each of those actually means. So personal service. Now this is really key. This is, as it says, really, it's really you want that individual to perform those services. So it's as simple as that. It's not you're not going to a business. So for example, a firm of accountants, you don't mind who does the work. You just want the job doing, and the firm of accountants provides a person. Then that wouldn't be personal service. But where you're going to that individual and saying, yeah, we've agreed, I want you to do this work, then obviously personal service exists. The key with personal service is always being around substitution. So, and it's often criticised because in practice, substitution doesn't always happen. It might be in a contract, but does it actually always happen? So it's really key. If it does happen, it's absolutely fantastic. And it's a real strong indicator that individual is in business in their own account and can genuinely be paid outside payroll. Julie, do you want to chip in?
Yes, I was just going to say you might be coming to this anyway, but just because you put it in the contract that they can bring a substitute, that isn't really going to be enough to pass the test, it's got to be something that would reflect reality, hasn't it, Angela? So
Absolutely.
a lot of these contracts for contractors will say, oh, they can send a substitute. But if you well know that their personal service company only has them in the company and they don't work with anybody else, then it's not really reflecting reality, and it's just there to try and tick a box, and it's not going to tick your box from the HMRC perspective, is it?
No, absolutely. And that's exactly what HMRC will say. They'll look at contracts, but they will want to know what actually happens in practice. So to make it work, substitution actually has to be that worker going out and finding the substitute, and that worker actually paying directly the substitute. And again, that's where it quite often fails. The organisation finds the substitute and actually pays the substitute, which is not, which is just not part of the test here, and it doesn't help at all. So it actually has to be that individual is going out, finding and paying the substitute, and not yourselves as an organisation. So you can't just pick, somebody from another pool. And quite often this falls down because it needs to be what we call an unfettered right of substitution. That means that you as an organisation really shouldn't have anything to do with that substitute, providing they're of a certain qualification, that might be your only proviso, then you will accept a substitute. That needs to actually be there. So as I say, this is, it's brilliant if you can get it to work. And quite often with clients, we say, let's try and get this to work in practice. Let's just do this and have it evidence there that we can make it work. But I think, as somebody might have just asked in the chat box, if you can't make it work, then we just move on to the other tests. It's not the be all and end all. In some roles, it's just not possible. You absolutely need that person. There's no question about it. That doesn't mean it's slam dunk and that individual is then has to be paid within IR35. You then look to the other tests.
You'd also, Angela, in relation to the question, if you've got someone that genuinely works as a self in running their own business within, and obviously the question's about a school setting, so they run their own business, you would expect them to have done all the checks and balances and have all the training and all the things that you would need in order to work in a school setting.
Yes.
So in many situations like that, that's what you're really looking for, that someone that's actually genuinely set up to do that. And if they don't have that in place, it's not really going to, it's a warning signal, isn't it?
It is. Yeah. And I think that's a really good point. You've got to make sure people have got the right qualifications or whatever it is that you need for that to work. But as I say, if you can't make it work, some roles, in the NHS, for example, you want a specific specialist, for a certain medical reason, then, you can't just chop and change and bring people in and out. It just personal service is needed, and we can't substitute in that scenario. But as I said, it's not, slam dunk that we're stuck then. We need to go on and look at all the other tests as well. So yeah, as I mentioned before, the criteria, we just really need to look at if you're putting any restrictions on substitutes there. As I mentioned, the last bullet point here is, if you're going out and procuring a service, like I say, from a firm of lawyers, firm of accountants, that's not about one individual. Yes, you might often work with one particular caseworker, but you go into a business and that's what we call a contracted out service. You're not engage in the services of an individual. So it really is that individual nature that sparks the reason why we really need to think about this. So the next test, we've looked at personal service. If, as I mentioned, whether that's an indicator that somebody should be within the IR35 rules. And when I keep saying within, that means that tax applies. Outside means that tax and national insurance don't apply. Then we move on to control. So we're looking here at whether that you as an engager control how, where and when this individual is actually doing their work. So is it akin to what we called a long time ago the master-servant relationship? So are you directing everything that individual is doing on a day-to-day basis? So you dictating the hours, the location, the methods of how they carry out that work. Obviously, all of that sounds very much like an employee. And therefore, if that's in place, regardless of whether somebody's got their own personal service company, they're telling you they've got a VAT registration number, they pay all the taxes. It doesn't matter. You have to assess this from the starting point. And if control is in place by you as an organisation, then that and again is a very high indicator that this person should be paid within the off-payroll working rules. Another area is is this individual coming in and not being given a specific project? So the best way to have control on the side that somebody is outside of IR35 is what we call it's a project-based contract or agreement. So they're coming in just to do a specific task. They can't then be moved on to another task because, of course, that would just purely then look like the individual is an employee, in which you move from task to task. So that indicates that you as an engager have a high level of control. Certain sort of sectors, it's a little bit more tricky because you could have somebody that's really highly skilled, for example, a pilot, and they might be super highly skilled, but they're following route maps, timetables, and everything else that's dictated to them by the airline. So we really need to sort of look at more into what they're actually doing and who's controlling what they're doing. If you as the end client actually dictates the schedule, the work location, as I say, that will be a high level of control. And then the other point is really around an agreed date to carry out the project. If that's you basically telling them, you've got 6 months to do this, they can decide where, when, how they're actually doing that, then obviously, you're just setting out for them, what you need doing by a certain time. How they get to that point or how they deliver that project is completely under their control. That would then be seen as a good indication that they're outside of IR35. Financial risks. Now, this one is actually a big one where we see clients get this wrong. And it's really around things like motor vehicles that they have for commuting, mileage costs, that type of thing where we see it go wrong. This has to be significant financial costs for this to actually assist in an outside of IR35 position. What we're trying to say here is this individual is in business in their own account, and they're investing significant costs to actually do their job. So that will be a specific vehicle, not just one to commute to work. HMRC specifically state on their guidance, if you go within the SES tool and the guidance there, that commuting is not included here. So if somebody's telling you, yes, they have a vehicle that they're commuting to and from your premises, that doesn't count as a financial risk. So it's got to be specialist commitment here, equipment here, and they're committing to actually spend that to carry out their job. It's not just quite often we say, oh yes, they've got professional liability here, insurance. That's just a few £100. Julie, do you want to come in on that?
So you might have just answered it. I was just going to ask whether in order to do the job they need to have specialist training that they update on an annual basis, and if they have to pay for that themselves, would that be something that you could look at?
It would be. You'd obviously just need to look at the cost of that. As I say, if it's just £100 here or there, then HMRC wouldn't say it's significant enough. But yes, if genuinely they are having to keep up their professional qualifications, they've got specialist equipment, they actually need to join certain bodies, subscriptions, that kind of thing. They can all add up. The biggest one is normally if somebody has their own premises, they actually are, paying for an office, a WeWorks office or something like that. And also if, as it says on that top bullet point, you might give them, 6 months to do a project. And if they've not delivered within that 6 months, it doesn't matter. You're still paying them the exact same amount. And they're actually going to lose. If they actually are quicker, and then they'll benefit from that, they can move on to the next project. So this is their business of their own account and sound management of the project. Whereas if they're slow and they don't deliver in time, they will financially be risking, not having that income for a period of time. So again, that's a strong indicator that they are taking financial risk in terms of how they're operating on a day-to-day basis. Clearly, somebody who is being paid an hourly rate is always going to attract more attention. So, we have to look at other areas. And as I say, it's looking at all of these tests as a whole and then seeing on balance where we think the status actually lies. Do we think they're employed, self-employed? Do we think they're inside of IR35 or outside of IR35? So as I mentioned, this sort of basis of payment is quite important. If you can have something that's project based rather than sort of hourly paid or a day rate, that is far better and much more of a financial risk indicator. There's also a question about, if there's on the SaaS tool that talks about, does the worker actually have to put right any unsatisfactory work? If they do, then obviously you would expect it's in their own time, then they are taking financial risk there. Whereas if it's just, yes, they put it right, but you'd pay them the extra day to do it, or whatever it could be, then obviously that's not financial risk. They're getting paid. So as I say, it's got to be significant. Integration is another key area. And this is really around whether we are thinking, is this individual part and parcel of the organisation? If anybody on the outside coming in, would they actually think that person's an employee? We've often spoke about, are they, back in the day it was like, were they on the phone directory? So these days it's things like, do they have an email address that's part of your organisation? That could be one thing. However, that's not a slam dunk that somebody's caught. Sometimes that individual will need an email address to access your systems, and you will have to give them certain rights. So it's a small point, but you just got to weigh up. If you've got lots of indicators pushing somebody to be inside of IR35, it may not help. As we kind of alluded to, does that individual work amongst other people who are employees? So is that individual just coming in to help with the additional workload? Again, they would be, treated as inside the rules. Even worse, does that individual actually have line management responsibilities? Are they responsible for other people within your organisation who are employees? Again, we wouldn't expect somebody who's not supposed to be an employee to actually have these line management responsibilities, to just watch out there. Are they entitled to receive any benefits? Quite often we've seen workers inadvertently offered healthcare benefits or corporate discounts that an organisation's employees get. You'd really be careful here that if people are genuinely supposed to be outside of IR35, you can't be offering these benefits to them. And then finally, how do they actually identify themselves? So if they were, out meeting, say, a supplier of your organisation, would they actually say that they're part of your organisation, or would they say they're an independent contractor? So one of the areas where I've seen this go wrong, and HMRC are amazingly quite good at looking on LinkedIn. And just be careful that the individual's not putting themselves on there that they are working for your organisation inadvertently, because obviously, that will be a very, very difficult chat to have with HMRC. So just be careful. It's supposed to be an independent person in business of their own account. Do they have a website? How do they present themselves online and on LinkedIn? Just be aware of that. Mutuality of obligation. This is something that really it's you as an engager. If you've got the obligation to provide work, and does that individual have the obligation to accept it? If we can prove that, for example, that worker doesn't accept every piece of work you offer them, then that's quite good at showing that we don't have mutuality of obligation. Now, this is one that HMRC always assume this exists in every contract, but it doesn't. And, a lot of us don't agree with HMRC's approach on this. So they just assumed it's always in place. But we've got plenty of cases here where it's actually, it's obvious that mutuality doesn't exist in every case. So we've got a case at the minute, which we call a PGMOL case, which has gone through the Supreme Court, which is actually based on referees. So this is your sort of below championship referees. And this, at the moment, has not been found in HMRC's favour, but HMRC have appealed. And this is purely on this mutuality of obligation point. The PGMOL officials have been arguing they cannot turn up for a game up to the day before. There's no obligation there. They have to come. They can basically say they're not coming the day before, and this is really around the fact they're saying there's no mutuality of obligation. There are various other tests that are involved as well, but we've been waiting for the answer on this, the actual result on this case for a while. So as soon as it comes in, we'll obviously update you on that. Okay. So what's not important for determining status tests? I alluded to this earlier when I mentioned about VAT registration. Quite often, you will get pressure if you as an organisation want to engage somebody and you've run through all the different tests, you've carried out the SES tool assessment, you're about to issue a status determination statement to say somebody's within IR35, then the first thing they'll throw back to you is, oh, I pay my own taxes through, to HMRC. I'm paying everything. Well, that doesn't really help at all because you still have the obligation to assess them. So it doesn't matter what they're paying. You actually still have to carry out the assessment. Because quite often, unfortunately, a lot of people are set up this way because they can pay themselves in a way that means they're not paying as much tax and national insurance as they would be if they're an employee. So they can pay themselves a very low salary to cover off a basic state pension requirements, and then they will take the rest as dividend income. They will be claiming all sorts of different expenses against their income that they won't be able to claim as an employee. So the actual amount of tax they pay will be a lot less. And of course, for you as an employer, HMRC want you to be paying the employer national insurance contributions, the class 1 national insurance contributions, which they're not getting if that individual isn't an employee. So just because somebody's set up with HMRC or they have a VAT registration really doesn't matter. It has no weight in the discussions at all. You still actually have to go through the tests. Obviously, it might be their choice to set up like that, but it doesn't matter for you as the engager. You have the obligation to make the decision and get it right. So when you engage with a personal service company, just to really touch upon this area, what does that really mean? So quite often it's what we call one-man band type companies. It's an individual who's got their own limited company, and we call them personal service companies for that reason. It's Joe Bloggs Limited. It basically is that individual who's doing all the work. They might have somebody else on there as a director or a company secretary. It could be their spouse or partner, but genuinely it's the one individual who's doing their work. And HMRC define a personal service company bizarrely at very low test. They only actually have to own 5% of a business and be providing personal services to be caught as a personal service company. How do you know a lot of these individuals are involved? It really is. If you're not sure, it's as simple as just doing a search on Companies House. That will then tell you if the personal service company, if you've got that limited company name, pop that in to the search and it will tell you how many directors are involved. So you'll know if it's just one or two that individual is bound to be the owner of that business. And a personal service company is something that doesn't normally have other employees, and it's usually just the one worker that's providing the services to you. So if, for example, you've got, you pay a firm, a limited company, a window cleaner company, for example, and it's not that individual, say they've got 10 different window cleaners and you might be provided with different ones, that's not a personal service company. Even if you might be speaking to the director who owns the majority of the business, it's not that individual coming out actually carrying out that service. So it really is that those companies that are just the one-man band type companies. And then often, as it says here, most of their income will be coming from yourselves for that period of time that they're working for you. Often there's obviously contractually, there's never a contract between the individual and yourselves as the engager and the end client. Instead, there will be a contract between yourselves and that limited company. And then you will pay that limited company and that individual will then decide how to draw down that income. So Companies House is the best way to check, are you engaging with a personal service company if you don't already know that individual. Yeah, we've covered those ones off, so I'll just flick on to umbrellas. Umbrella companies are just something to flag. If you are engaging somebody through a chain of agencies, for example, Always be clear when you're engaging with an agency how that agency is actually paying that individual. If it's on the agency payroll, brilliant, but just do that bit of due diligence just to double check, because if that individual is being paid fully through the agency payroll, they are on somebody's payroll, so you do not even need to consider the status tests or the off-payroll working rules. If not, quite often agencies will actually have that individual set up to pay the PSC, the personal service company. You then still have the obligation as an engager to carry out these tests, carry out the status determination statement, and give that to the agency. Then the agency has to actually apply pay as you earn to that income. So just don't be confused where we might have a chain of different intermediaries. And so I wanted to mention umbrellas because, again, there are various different umbrella companies out there in the marketplace. Some genuinely are absolutely fine. So it's what we call a full pay as you earn umbrella. So that individual, whatever they are paid, they will be paying full pay as you earn on that income. But then there are also others in the marketplace which will only be paying pay as you earn on a very small proportion of fees. So if somebody says they use an umbrella company, just wanted to flag, just ask, is it fully pay as you earn? And if it is, again, no further requirements. So it's just important that you're really clear exactly who you're engaging with. So coming on to the HMRC tool, so this has been with us for quite a while. We call it SEST for short. It's been updated various times, but not in any significant manner. Most recently, it's just been updated in terms of the way the questions are set out. As I mentioned, it's there, it's free. And you go through the questions. As I mentioned, we've got sort of headings on the slide which are talking about personal service, substitution, how that worker is carrying out their work, whether they're taking financial risk, the integration, how involved they are with the business, and it also then asks about contracts. As mentioned as well, HMRC will stand by the result. So at the end, you can print off a result. HMRC don't get that, so don't worry when you get to the end, or if you want to email it to yourself, is that's going to flag anything to HMRC? It doesn't get tracked at all. But it's then there as proof that you've carried out that status determination. You can also use that to send to the worker, because it's got all the questions on there and the reasons then for why you've arrived at that decision. And obviously it's a HMRC tool, which also then helps. And the outcomes are at the bottom. If somebody is, as I say, not got their own limited company, then you're just looking at whether somebody's employed or self-employed. So it will ask you that at the very beginning. It will also ask you at the very beginning, whether they're an office holder, and then quite quickly it then tells you full pay as you earn. If you've got somebody who's got a limited company, their own personal service company, then it's whether the off-payroll working rules apply, which means they're inside and you're actually having to pay tax and national insurance, or whether they don't apply, so you're not having to pay tax and national insurance. And then finally, we get the really unhelpful, unable to determine, which unfortunately happens in quite a lot of cases. And HMRC have been working on this, and one of their targets is to drive down the number of unable to determine outcomes. What often happens with our clients is if they get an unable to determine outcome, they would then come to us and say, can you give us a view on this? Which then we do, and then they've obviously then got that there as evidence. So hopefully we'll get more updates on it, but unhelpfully we do get a lot of unable to determine. So just on the actual main features, you've just got to be really careful, as I said, that a lot of the questions are understood and are answered correctly. What we don't want is that it's a simple box ticking exercise just to get somebody an outside of IR35 result. That will not be seen as something that HMRC will stand by. They will want to go into the questions and really understand them. If it's genuinely answered correctly, then of course that's really good evidence. We need to really look at, as I say, the different sort of questions in there, and financial risk, as I said, is a big one we quite often see that's completed incorrectly. And then really it's looking a bit more these days. The latest updates are around whether that person is genuinely in business of their own account. Some difficult cases that we've come up with and that I just wanted to mention, the SES doesn't really account for, because it's it's kind of obvious that some of these people should be outside, but unfortunately the SES tool will either put them inside or give you an unable to determine outcome. It's around trainers and guest speakers. Quite often, they're just brought in for a very specific event or just to deliver a certain course, and potentially it's their material, it's their time, their structure. You're just bringing them in to kind of cover off an obligation that you have. Now, as it says on there, it's the training material is really important, and there's no way we can really reflect that within the SES tool. So unfortunately, it might come out with an unable to determine outcome. But if you do use trainers on an ad hoc basis, that trainer is working for lots of different other organisations, and you're just bringing them in to just deliver a certain course, then they should be outside of the rules, or genuinely self-employed if they don't use the limited company. Again, guest speakers, it's quite self-explanatory. So we have had some other areas in terms of updates from HMRC. They have given links in there as you go through the SES now, so you can actually look at the guidance as you are completing the SES. And it really is useful to look into that guidance. So that the SES tool has guidance notes for every single question, and it gives you, if this is the case, then you need to answer yes or no to the question. So really do use those extra guidance. And we had, as I say, the hope that we'll get less unable to determine outcomes. As it mentions there, we provide a helpline for anybody who's a PS Tax Club member, and that's part of your helpline service. There are no additional fees for anybody who's a client to come to us with an unable to determine outcome. We would look at that and give you a steer. It says finally, new version coming soon. Yes, we've been waiting for that quite a while, and I think the reason why we've not seen it is because of this PGMOL case. It's such a big case, and we are aware that HMRC have been preparing dependent on the final outcome with the Supreme Court decision. So I think there won't be seeing any updates until that's actually happened. The final part of my presentation, I was just going to cover off the new offset rules where personal service companies are used. So this is something that's quite important. So where you've got somebody who is a self-employed sole trader, so your Joe Blogs, not your Joe Blogs Limited, then it's always been the case that should HMRC come out and do a review and not agree with you on the status of that individual, you could always claim offset for any tax that have been paid through their self-assessment tax return. But when the IR35 rules changed and the off-payroll working rules came in, there has never been until now the ability to offset for any tax where you're using the services of somebody who has their own personal service company. So the Joe Blogs Limited. So I had quite a few really annoying cases with some quite large organisations where the organisation had been very responsible, decided to carry out a review a couple of years ago at this one local authority, and they'd identified that potentially at the beginning, April 2017, some individuals were genuinely okay and outside of IR35. But guess what? A few years later, they're still here. They've been moved from task to task. We now need to consider their employment status and the off-payroll working rules. So we actually ended up making a disclosure to HMRC on a few individuals, and most of those individuals were engaged through their own personal service companies. They had to pay around £1 million. So a significant amount, but obviously, they were very risk averse. They didn't want to sort of have that there in the background and not settle it. They wanted to get things right going forward. So very responsible. But we had no way of claiming any of that tax or national insurance. Those individuals are paid through their self-assessment returns, through their corporation tax self-assessment returns for the company. There was no way of offsetting. And annoyingly, what HMRC did, because they can't accept double taxation, was write to the individuals involved and ask them if they wanted to reclaim the repayment for what they'd paid through self-assessment. So it just didn't, it didn't feel right, sit right. And the reason why HMRC didn't have anything in place was because it was too complicated. As I mentioned, these individuals have got the completing self-assessment tax returns for any salary that they're taking from their personal service company. And then the personal service company is completing a corporation tax return. We've got class 1 national insurance, class 2, class 4, all sorts being paid. Well, what has eventually happened is the HMRC have said that it can't carry on, and they consulted on it for a year before it came in April. And I was one of the first people they wrote to, because I had this case with this local authority where we said we would settle, pay the tax, but we knew this was in the background. We said, can you put in the agreement that we'll just put a hold on this, and that when these new offset rules come in, that we can actually benefit from them? And we did. So they put in place what they called a standstill agreement, which basically meant we were all agreed, but we were waiting for the new rules to come in. So hopefully now my client will have a significant repayment coming back to them, which obviously for lots of local authorities is really much needed at the moment. But what it means is there is a basic estimation of what's been paid by that individual, and there will be offset for any tax and national insurance that worker has actually paid through their self-assessment and corporation tax return. As it says on there, it doesn't extend to the employer's class 1 national insurance that they should have been paying, but obviously it's still a significant result here. So we are able to do that, and this is not just from for anything that's from April onwards. If you've got a case that's going back with HMRC back to April 2017, this offset can apply going back that far. So yeah, if you've entered it, made a disclosure, or if you've got a HMRC review, then it really sort of look into this. What's really important from a going forward perspective is the only way that you can claim offset is when you're capturing the right information from HMRC. So on this slide, you might not capture exactly everything here. So my advice to you would be make sure you do, or you're finding this information out going forwards. So that what the HMRC will need to actually claim offset is the worker's name, address, worker's date of birth, the national insurance number, the personal service company name and address, their VAT registration number or their company registration number. So these might not be things that you're asking for at the moment. So my advice would be just to, make sure that you bring these processes in going forwards. So briefly, just in summary, what would we suggest is a textbook approach. What we'd want is prior to you engaging with the worker that you're actually carrying out these steps. So we're showing that you've undertaken an assessment with the SES tool. You've got robust procedures in place so that everybody in the organisation who's carrying out this assessment understands what they have to do, and the right training is in place, so they've got reasonable care there, that they understand the questions. Make sure that the SDS is being issued as it should be. Make sure that that there's an understanding that there's a disagreement appeals process in place, and keep records, keep the evidence of all of these things. There's no point in saying, yes, we do this, we do that. Can you actually evidence that that's actually happening? Yeah, where else we say here, where does it go wrong? So this is where we sort of paying lip service. So we really need to be clear here. So the contract terms in place prior to the SES being completed, sometimes that does happen. We might then have to do the SES at a later date, but ideally we should be doing it before we're engaging the individual. Where it goes wrong again is where there's a lack of awareness in terms of the rules and the engagements that are in place. Understand, is there a contractual chain? Do we have agencies involved, umbrella companies? Another area it goes wrong is quite often organisations, unfortunately, will say to the worker, "Oh, you complete the SES tool." No, that's not going to stand give you any sort of credit with HMRC if should they come out and do a review. It needs to be completed by you because you can be more objective. That individual is not going to complete the SES in a way that will be genuine potentially. Yeah, we see it going wrong where we don't have SDSs being issued and we don't have the disagreement process being communicated. We do need evidence here for some of the questions that are on the SES tool. So just finally, just to sort of sum up from me, it is very hot area for HMRC at the minute, particularly in the public sector. A couple of years ago, November 22, HMRC wrote to all local authorities as a more of a light touch approach, just to ask how many people you engaged as self-employed, how many people did you engage through a limited company. They've now gathered obviously all of those facts. They promised they wouldn't launch an investigation, but they've still got that information. So They can carry out a review at any point in time. As I mentioned, the police forces have had a lot stricter approach. So all forces that have been asked to give HMRC a full list of everybody they're engaging outside of payroll. Do you have that information if HMRC came to you? So do you keep a register of everybody who's engaged off payroll? Just be aware that the HMRC are very active. The CES tool is useful, so use it, but unfortunately we don't always get the right answer, so please seek external advice and document that advice as part of the process if you end up with one of these unable to determine outcomes. And then finally, as I've mentioned, I can't, really push this enough. Making sure that people who are carrying out these status determination statements understand the rules is really important, and it really does help tick the box from HMRC's side that you are, as an organisation, are taking reasonable care, and people really do understand the questions and the answers that they're giving. So that is it from me.
Oh, thank you, Angela. That was absolutely amazing. We have a couple of questions. So the first one's come in terms of locum for legal services. And I understand, the question is, this is a real mix of tests, because obviously if you provide legal services, you're a professional, so you often have control over how you provide that service. But I think you've got to look at what they're actually doing. So you may have, for example, someone that comes in to do into your internal legal team that does a review of your legal team, and so they're sort of independent of the doing that sort of review. That could be outside, but if they're actually providing its services to you as an organisation and working alongside permanent employees, so what they're doing is taking a role that a permanent employee ordinarily would do, even if it's just for overflow because you need someone additional for a temporary period, chances are they should be with inside payroll. I provide personal services. I provide professional services. I have control over of how I operate, but I am definitely an employee. So you've got to have that sort of smell test as well. If it looks and smells like an employee, it really is, isn't it? And I think the other one, another good question, that it's often straightforward if you have small and distinct projects, but what about if you've got a large scale project where you need to bring a whole team of workers in? They're not needed forever, but they're needed to set up the project, like building projects or systems implementation. And I often think in these types of situation, you may have your own views, Angela, but if, for example, you were building a house and you brought in a team of contractors, the brickies wouldn't be there permanently for the whole time you've got the house being built. They'd come in to do their bit and they'd go off and they'd have other projects. They may not even be there every day because they may have some other work they need to do in the morning, then they come in the afternoon. So they have that sort of way of managing their business, how they do your services. The electrician comes and goes, and so you've got to have that feel. If you need a system implementation and you as an organisation are going to directly contract with all those individuals to come in, and they're going to be there for a long time. So we've worked with PS Tax on a similar sort of a building project, a large scale public building project, where they brought in procurement specialists, because you need the procurement specialists to get the contractors in place. And so these are procurement specialists. They're all set up with the personal services companies. That's what they do. But some of them have been working in this procurement area for this particular organisation for 2 years. And it looks and smells like an integrated permanent sort of role, even if it's a fixed term role. If you don't need it forever, if it's a fixed term role, you should be thinking about it as being inside. What do you think, Angela?
Yeah, I've seen this. Yeah, I absolutely agree with everything that you've said. The only time I've seen anything like a large project being outside is, you go to an outside company and say, you sort all of this for us. You find the contractors, the different, people that you need for the project. Then potentially, you're okay because you're contracting out that service for somebody else to provide. But if genuinely you are going and you're having to bring in these people, and you're actually interviewing these people, selecting these people, paying these different people to do parts of the project, then, yes, unfortunately, you still have to go through the process, and you might be happy that it's distinct. And even if it does, go on, a couple of years, you could genuinely sort of say, yes, that is distinct. Some of these projects do take time, even where they're specific, don't they? But quite often, then somebody's still there, and you think, oh no, they're integrated. All of a sudden, they've got line management responsibilities, and they're looking after other employees. So that's really where these things can go wrong.
It is, and I think one of the questions is, you do have to look at each individual. If you're bringing in a team of 20, you look at each individual.
Yes.
And you do your due diligence in respect of each individual. Are they genuinely running a business in their own? Are they going from one fixed term project to another fixed term project for long periods? They are an interim worker. It doesn't mean to say that they genuinely have any sort of, if they work for you full time for that period of time and then work for someone else for a year full time, doesn't necessarily mean that they are definitely running their own business. So you have to do your due diligence on each one. Often Google them to see, look up them up on LinkedIn. Do they have, how are they advertising their services? How do they present themselves? But all really good questions, and thank you very much for contributing. And thank you again, Angela. That was a really, really good session. I really enjoyed it, and I got an awful lot out of it. One last question, Angela. Do you as PS Tax do any employment updates if anybody wanted to sign up?
Yes.
So if you want to do that, if you want to send us your details, we can pass them on to Angela. Or I think we can, Angela, do you want to type your email address into the chat function and then they can contact you, or however they contact you?
Yeah, that's fine. It should be on the
It's
slide,
there
but
on
you
the
might be able to
slide.
see it very well.
Yeah, it's there.
Yeah.
That's fine. So if you want to do that, we will send out the slides to you, and the recording, as we say, we have recorded it, will be available. Thank you everybody for joining in.
Yeah, thank
you. I can't remember what we're doing next month, but we will be in touch as usual. And thank you again, Angela. And I hope you all have a lovely, very hot and sunny Wednesday. Thank you very much.
Thank you.